The Supreme Court recently denied a stay that would have protected a state's Second Amendment sanctuary law. This issue is now back in the hands of the Supreme Court for reconsideration, so let's break down what is happening. Now, before we jump into this video, I want to thank the sponsor of this video, which is Attorneys on Retainer. When it comes to self-defense protection, don't settle for just any company. AOR is backed by a real law firm. It has real attorneys on staff that focus on helping you in self-defense cases. With AOR, you get direct access to an attorney 24/7 who can give you immediate legal advice if there's an incident. So if you're interested in protecting yourself and your family, check them out. You can go to the link down below that will be in the details section in the pinned comment. And if you use code ARMEDSCHOLAR, you will get $50 off your individual sign-up plan or $25 off a family plan. So like I mentioned in the intro, in this video, we're going to be talking about a significant Second Amendment case that's once again back in front of the Supreme Court. This case is dealing with a state's Second Amendment Preservation Act, also known as the SAPA law. We've discussed this case before because recently the Supreme Court denied an emergency request for a stay, and that would have protected Missouri's SAPA law. After that emergency denial order, this case was then sent back down to the 8th Circuit, who recently issued their new decision in this case. But now Missouri is seeking once again Supreme Court consideration on the final merits of this case, and this is back in the hands of the Supreme Court. And even better, now 15 states have joined together in support of Missouri, and they're all arguing that they also, as states, should be allowed to put in place this type of two-way sanctuary law. Now, for those not familiar, back in 2021, Missouri passed a law called the Second Amendment Preservation Act. That law set the state's interpretation of the Second Amendment and also set restrictions on the support and funding from the state that it would provide to federal agencies and agents in their attempts to enforce inconsistent federal laws that they believed violated the Second Amendment. The law also created a civil remedy where anyone, a resident of Missouri, could sue a Missouri official if that official helped the federal government to violate their Second Amendment rights. The Missouri law is similar in nature to the Texas abortion law SB 8, and also the recent Supreme Court decision in a case called Whole Women's Health. With the Texas and Missouri law, the structures are essentially in a way that there are umbrella injunctions that cannot be issued against the state or the Attorney General, since the state or the Attorney General aren't actually the ones enforcing the law. Instead, it is civil remedies that are filed by individuals, so you would have to get an individual injunction against every single resident who brought a civil suit. Now, in this Missouri case, the District Court on review ruled in favor of the Biden administration, and they struck down the Missouri Preservation Act in its entirety. Now, in response to that, the state of Missouri then appealed up to the 8th Circuit Court of Appeals. Missouri also asked for the 8th Circuit to stay the lower court's decision while the appeal was taking place. However, the 8th Circuit denied that stay, and that's what led Missouri for the first time to go to the Supreme Court on an emergency basis at an interlocutory posture, and they sought an emergency application for a stay of that lower court decision. However, on review, the Supreme Court issued an 8-1 decision denying that request for an emergency stay. Only Justice Thomas was in favor of granting the stay to the state of Missouri. Now, after that, and after the Supreme Court denial, the case was then sent back down to the 8th Circuit, who then held expedited arguments and decided this case. The 8th Circuit ultimately ruled in favor of the federal government once again, striking down the SAPA law in its entirety. But now Missouri has filed their writ of cert to the Supreme Court, and they're asking for the Supreme Court to review this now that it's on its final merits. In the petition, Missouri presents some very important questions for the Supreme Court to finally consider. They state that can federal courts second-guess a state's reason for exercising 10th Amendment authority? Also, does the Constitution prohibit states from exercising 10th Amendment authority when motivated by a concern that a federal statute is unconstitutional? Missouri goes on to argue in the petition that before this case, it appears no federal court had ever blocked a state from exercising 10th Amendment authority simply because of the reason the state expressed for exercising that authority. The 8th Circuit did that here, striking down a law solely because the act said that the legislator believes a certain federal statute is unconstitutional. The 8th Circuit's holding creates multiple circuit splits and is as wrong as it is unprecedented. Now, one of the things Missouri is pointing out in their petition is that the 8th Circuit essentially said that the structure and potential operation of this law is valid. but they ultimately struck it down only because the underlying Second Amendment purpose is something that the Eighth Circuit did not like. Missouri also argues that the Eighth Circuit went against clear precedent to reach this decision and absurdly found that the court could say that compliance and non-action by state of Missouri officials could be characterized as action in enforcement. So they went weird and they said that inaction is actually action, and therefore we can issue this umbrella injunction. But the good thing with this is now this lawsuit has received support from multiple states who are also arguing that they potentially would like to put in 2A sanctuary laws, and that the Supreme Court should review and ultimately hold that a state can do this. So the states that joined in support of Missouri are Alabama, Alaska, Arkansas, Florida, Idaho, Indiana, Kansas, North Dakota, Montana, Oklahoma, South Carolina, South Dakota, Texas, West Virginia, Wyoming, and then also the Arizona state legislature joined in support of this brief and in this lawsuit. In the brief, the 15 states argued that the Missouri legislature concluded certain federal laws were unconstitutional under the Second Amendment, so it prohibited Missouri officials from enforcing those statutes. The United States brought a facial challenge asserting that Missouri prohibition was itself facially unconstitutional, but neither the District Court nor the Eighth Circuit identified or applied the applicable legal standard for facial challenges, as stated in the case Anderson. That alone warrants vacature. The many defects in the Eighth Circuit's textual analysis of the SAPA law does so too, as does the panel's improperly relying on the Missouri legislature's reason for adopting SAPA. The Eighth Circuit analysis is infused with the view that 1. Every firearms regulation enacted under the Commerce Clause is in fact constitutional, even as applied to another state despite the lack of controlling authority from this court. And 2, the Missouri legislature could not analyze that question for itself and instruct Missouri officials to simply avoid enforcing statutes the legislature believes are unconstitutional. But they state both are wrong. They then go on to point out that the district court's complete injunction against this entire law, applying it to all officers and agents and to everyone, is improper and goes beyond the authority that a court has. They state that the district court nevertheless purported directly to avoid SAPA and immunize Missouri officials from this suit by private parties not before this court. This court should use this case to clarify the limited scope of the federal injunctive power. So it's great to see so many states join to actually support a 2A sanctuary law. They're joining here as amici, filing an amicus brief in support of Missouri. This is, of course, a huge Second Amendment sanctuary law case and a significant challenge that I think maybe a lot of these states who joined would potentially like to pass on their own to protect their own residents against, federal Second Amendment laws, and also just maybe pass other laws that have a similar nature, similar structure, but maybe don't deal directly with the Second Amendment. But it's great to see so many states join Missouri and argue that the Supreme Court should in fact support these type of 2A sanctuary laws. So now we're going to see how the federal government will actually respond to this now that the Trump administration has control of this. They've asked for an extension of time to file their response, and it's going to be interesting to see how AG Pam Bondi and her office decide they want to handle this case. So as we get more information, as things develop, I will let you guys know. If you like this video and you'd like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm, and it signals to YouTube that you guys see value in these videos and in this type of 2A news. But as always, thank you all for watching. Don't forget to like and subscribe, and never forget this nation was built by ARMED Scholars, and this nation will be maintained by ARMED Scholars.